part 2 of lesson number 12, and we're right in the middle of the Bill of Rights as we study the miracle of America and what gave our country their great heritage. Now we're going to begin this lesson with the fourth article, or the Fourth Amendment of the Bill of Rights, and that's very important to everybody that's listening to me. Let me just read it to you. It says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable," notice that word, unreasonable search and seizures, shall not be violated. And then it goes on to say that if there are warrants, they also must be very carefully issued so that the rights of the people are not violated in connection with them. That's this famous Fourth Amendment. Now, the founders thought that the inalienable rights of life, liberty, property, and the pursuit of happiness required the element of privacy. And so that's your first blank there under A. You want happiness. Now, if you had lived under Nazism or fascism, or if you lived in a communist country today, you have the constant fear of that knock on the door as the national police come in and search and seize and may send a person to Siberia or a concentration camp. So capital B is this wonderful feeling that we are secure in our homes as a result of this great Fourth Amendment. And it's copied by the states in their constitutions as well. All right, Roman numeral 2. Notice that you are only protected against unreasonable search and seizure and arrest. For example, would it be reasonable in connection with an authorized arrest to check the offender's car or immediate premises for narcotics, for guns, for accomplices? Would you consider that reasonable? As the police go out to protect you, they make an arrest. Would you consider that reasonable? Well, the founders did. They would consider that reasonable. So the answer is yes. And Roman numeral 2, now we're talking about unreasonable. Did you get that in the blank? All right, now this one would be yes. Would it be unreasonable for the police to chase a criminal across private property? They're chasing a robber. He happens to go through your backyard. Is it reasonable for the police to continue chasing him, even though it's on private property? It would be reasonable, and therefore the word here is unreasonable. No, it would not be unreasonable. So your answer to B is no. Would it be reasonable for the police to enter on private property in order to make certain it is secure? Well, we expect the police to do that, don't we? And they come in to check it. Business houses expect it. And when you're away on vacation, you hope the police are going by every once in a while with a flashlight, sort of look to see if it's been broken into. And so the answer to that is yes. Now, would it be reasonable to open mail, tap telephones, or put on microphone electronic surveillances of individual citizens? And the answer is no. That's no, unless, and the law makes some exceptions, there is danger to life, to human life, as in kidnapping cases, or it involves a threat to the security of the whole country. Then the law makes allowances for it. And while I was in the FBI, it was not permitted to ever pass on this yourself. You had to go up through Mr. Hoover, who would never do it on his own. He then went to the Attorney General or the White House and said, would you consider this a situation in which we would use these technical devices? I had a great respect for Mr. Hoover's careful concern for civil rights. And I worked just a couple of steps down from Mr. Hoover during World War II. And I think I got to know him a lot better than many of his critics. This man had great respect for the rights of individuals. Now, Roman numeral 3. I guess you got those other two blanks, life and threat. All right, Roman numeral 3. Warrants are required to protect the basic rights of freedom and privacy of the individual. And in order for an officer to obtain a warrant, he has to do certain things. First of all, he has to go before a judge. See, it's not in just the executive branch of government. He has to go before the judiciary, a judge, and show that there is reasonable evidence, and that's your blank, to believe that this warrant is justified and action should be taken. And 2, that there is probable cause to believe that the person named in the warrant is responsible for the offense. Offense. All right, now notice what the officer has to do. He has to take an oath and swear that what he has told the judge he firmly believes to be true. True. And you see, if it subsequently was proven that he deliberately did this deceitfully for some personal aggrandizement, he can be prosecuted, you see, for having perjured himself under oath. So 3 is true. Now, actually, the founders were reacting to their memory of those terrible writs of assistance that were issued by admiralty courts, in which they would come in and knock on your door and come in your house in the name of the king, tear up the mattress, tear cupboards off the wall, dig up the floor, etc. And you say, "What are you looking for?" And they'd say, "We don't know, we're just looking." That's a fishing expedition. And that's why the founders put this right into our Constitution. And so your blank is writs, W-R-I-T-S, not R-I-T-Z. Writs of assistance. All right, now we come to another famous one that you heard a lot about, and that's the Fifth Amendment. Now, the Fifth Amendment has 5 parts, and it too is to protect your life, liberty, property, and the enjoyment of happiness. All right? If you're going to be charged with a crime, it isn't to be publicized just because somebody suspects you. It has to be ventilated through a grand jury. Grand jury, and that's your blank. It has to be ventilated through a grand jury. All right, what's that? Well, a grand jury is 12 to 23 of your neighbors who get a chance to come into the courthouse and sit down and listen to what somebody says about you. And very often grand juries said this is just a lot of local gossip. There's no real evidence here at all. And they do not return a true bill. They return a no bill, which means they don't agree, there's nothing to it, and you're not embarrassed by these reckless charges. Now that's what that was for. That was to protect you. All right, now in the states they have grand juries, and I should mention this. Many of the states have either eliminated grand juries and just used a general information, or they reduced the number in the grand jury. But personally, I feel the grand jury procedure is very, very important to preserve, because citizens can go in and ask the courts to allow them to have a grand jury and investigate corruption, etc. That's a right of American citizens. Be careful about losing the grand jury prerogatives in your state. Now, no person can be tried twice for the same offense. Now, they did that in England. A fellow would be liberated by the jury, then they'd find some new evidence. Well, then let's prosecute him again. And this time, why, maybe they had enough evidence to convict him. But in America, it's different. We recognize that sometimes a person who is guilty will be turned loose because of inadequate evidence. And the philosophy in America, at least of the founding fathers, was once you bring a person to trial, take it through. And if you don't have enough evidence to convict him, turn him loose. If he subsequently turns out to be guilty, just leave it to God. If a person has a possible future prosecution hanging over his head the rest of his life, this isn't happiness. That's not America. Now, once a jury has said not guilty, he's free, even if the evidence subsequently shows he was guilty. Just leave that to God. All right, that was their beliefs and the way they looked at it. Now, no person should be required to testify against himself. Now, that was to protect us against the torture that they used to use in Europe and still do in many parts of the world. Get a confession by torture. And so the founders put it right in there. You don't have to confess. You don't have to testify against yourself. And if you do, it must be done voluntarily, knowing that you could have an attorney to advise you if you wished, and that it can be used against you in a court of law if you do confess. You need to know that before it's done. That's what we've done to try and protect the freedom and the rights of the people. All right? Now, did you get testify for Roman numeral 3? Now 4. Nor can a person be deprived of life, liberty, or property without due process of law. process of law. So you're in prison, you're entitled to your hearing, you're entitled to the day in court under the American system. Due process. Nor can you be deprived of your property for public use without just compensation. You see, government is supposed to protect property. But as we become members of society, every once in a while we need some property for a freeway, or we need some property that is in a critical position that needs to be taken. That's called the doctrine of eminent domain. And as members of the society and the community, we imply an agreement to that. But if the government ever takes any property, they have got to make sure there is just compensation. And you see, sometimes it won't be just the value of the land itself or the property. Sometimes, you know, they put a freeway right through a beautiful farm that's irrigated, and that'll cut the whole irrigation system in two. And so they not only have to pay the value of the land, but the damages, you see, that go with it, that they've damaged the whole lower section of that farm. All of that has to be, or it won't be just. Another important thing is whether or not this is being appropriated by the government for public use. They cannot do this for private use. And this was the case in urban renewal, you know, coming along and taking a lot of people's property and then turning it over to private individuals for development. That was a very serious question in connection with urban renewal, and really hasn't been settled in the minds of many legal scholars. All right, now there's Sixth Amendment. Ready for the Sixth Amendment? Once a person has been indicted for a federal crime, he has certain protective rights. Certain protective rights. Number one, the accused is entitled to a speedy and public trial. Public is your blank. A speedy trial. Well, a lot of trials aren't speedy. And the government has been remiss, both on the state and the federal level very frequently, not providing adequate services so that a person accused of a crime can be processed more rapidly. Of course, if he's put out on bail, he's free anyway until the court docket can be cleared. But that's a real problem. Now, a public trial is for the protection of the defendant. So once in a while, you'll hear a judge clear the courtroom. That means that it's in the interest of the defendant, because of all the noise and ruckus or whatever else may be happening, to clear that courtroom, except maybe for one newspaper reporter and one or two people to be there to tell in case something goes wrong and this court turns into star chamber, you see, and the defendant has his rights damaged. All right, Roman numeral 2, the accused in all federal cases are entitled to have a jury, all federal crimes. And of course, in a moment they're going to provide the same for damage cases in federal cases too. They're going to have a jury there too. We'll get to that in a minute. Okay, Roman numeral 3. The jury must be selected from the state and district where the offense occurred. Now, King George used to threaten to carry the colonists off to England for trial. He didn't do it, but he threatened to. And in many countries that's done. They arrest you and take you away from your home, take you away from your witnesses, take you where you wouldn't have a jury that would understand or be sympathetic. So it's right in our Constitution. You have to be tried by a jury, and they have to be from your area, from your state and district. And you must be told what they're going to charge you with in the court. The accused must be informed of the nature of the offense he is supposed to have committed. Now that happens when they serve the grand jury's findings on a person. At the time you're served, it describes what they are accusing you of, what they felt there was probable cause to believe you might have done. So you do know what you have to defend yourself about. And then you're entitled to a reasonable amount of time to prepare your defense. And the defendant is entitled to be confronted by his accusers. Now here's something interesting. Sometimes a wife will go to the police and say, my husband is involved in organized crime. I don't want him killed. Or she will say, my husband's been accepting bribes, and it's going to get worse and worse. I just feel like something ought to be done so that he wouldn't be doing this anymore. Well, that person is called an informant. an informant. And they tip the law enforcement people off to the fact that something very serious is happening. And so they go out and collect the evidence. Now they become the accusers. Do you get the distinction? Because unless informants remain anonymous, a wife or somebody who's trying to help her husband by reporting his involvement in organized crime, something like that, they would never go to the authorities. You have to protect those who want to try and help the government, the officers of law and order, clarify, clean up things. But the accusers are those who go out and get the evidence and say, this indicates that you did thus and so. So a defendant is entitled to confront his accusers, which would be the officers, not the informant, but the officers. Now, the defendant, the accused person, is entitled to have a compulsory process, meaning the power of the court, in obtaining witnesses in his behalf, and that's your blank, in his behalf or in his favor. Because a lot of people in very scandalous cases where it's just very, very controversial, people do not want to become involved on the side of the defendant even though they have something good to say about him. And in the interest of justice, the Constitution says the force of the court will go out and bring in people who know things that would help the defendant, just as it will go out and bring in people who have evidence that he's guilty. And number 7, an accused person is entitled to have the assistance of a lawyer. That's counsel for his defense. The law is technical. And every once in a while, you could get up and tell your story. That's the way they used to do it in the days of the Anglo-Saxons and ancient Israel. But our law is so technical that you need someone who's well versed in it and can be sure that your rights are adequately protected as the law provides. And so everybody's entitled to one. And if you were too poor, then the court appoints an individual. In early days, it was someone who was just out of law school. He did it for experience. But that isn't quite fair either. And so now the judges will more or less go down a list, and the attorney is paid for defending a client who can't afford to pay himself. All right, defense was that blank. All right, now the Seventh Amendment. Seventh Amendment deals with civil suits and has 2 parts. Now, I mentioned earlier that the Constitution itself said anyone accused of an offense in a federal court is entitled to a jury. What about people who are charged with having damaged someone? It's a federal case, but it involves damages. Now what about a jury? Do you want a judge to decide the damages and how much should be granted? Or you want a jury to sit there and listen to the facts and come up with a judgment of what the damages should be? Founders thought it should be a jury. And so we have in this Seventh Amendment a provision that if the damage suit is for more than $20, you can have a jury. That's $20. Now the second part provides that a judge cannot substitute his opinion for that of the jury. The jury came to a decision of what the facts were, what the damages should be, or whether or not the person is guilty. The judge may have a different feeling about it, but his opinion is not to be substituted for the finding of fact by the jury. That's what the amendment provides. Capital A, the blank is opinion. He can't substitute his opinion. But here's something the judge can do. He can order the jury to bring in a verdict of guilty when he knows that the requirements, the elements of that particular offense have not been proven by the prosecution. There has not been a valid case made. The jury may not know those technicalities, and so the judge can rule that they have to bring in a verdict in favor of the defendant when there has not been a valid case made against him. And that's your next blank, valid. And when the judge finds that he doesn't know whether the jury was even listening or not, but there has been a definite mistrial in this case. The jury did not perform its function, and it's brought in a verdict absolutely opposite to the evidence. He can declare a mistrial, and the defendant goes on and is retried again before a new jury. So that's your blank there is evidence. When the judge just feels that there's been a real violation of the basic elements of justice here, according to the evidence submitted, why then he can make that declaration. Evidence. All right? Now the Eighth Amendment. The Eighth Amendment. It has three parts. In the first place, it says the court cannot put excessive bail on an individual. Well, when is it excessive? In capital offenses and some other very serious crimes like sabotage and espionage, the judge doesn't have to allow any bail at all. But if he is going to allow bail, it must not be excessive. Well, bail is to keep a person from running, keep him from fleeing. And so there has to be enough to make it worthwhile for him to stay, because it's forfeited if he doesn't show up at the trial. But it mustn't be excessive. And the second part is that the fines put on an individual must not be excessive. Well, a fine was considered excessive if it was so much that a man couldn't pay it and make a living at the same time. He just couldn't do it. One of these cases came up in the court just recently. And so fines is your blank. It mustn't be excessive. Roman numeral 3, a convicted person shall not be subjected to cruel and unusual punishment. Well, what's that? Well, there are all kinds of cruel and unusual punishments. I'll tell you, they used to think of them in Europe, and the colonies used them somewhat themselves, and in the Asiatic countries, they have really brought cruel punishment into what you might kind of consider a fine art. Anyway, we didn't want it in this country. So we've tried to eliminate the stocks and ducking in water and that sort of thing. There's only one that I'd like to call to your attention, which maybe has some therapeutic value that's being overlooked. Back in the days of ancient Israel, they used the flat strap for the strapping of a person. And it provided that the judge had to count the stripes. And it had to bruise. It couldn't. If it broke the skin and caused bleeding, etc., then everything else was forgiven. Well, some people got to using the whip like a cat o' nine tails. You can kill a man with that. And so whipping got into what should we say, a bad reputation, and was outlawed in most of the states. In Canada, they kept it until very recently, and a person could elect to take the whip rather than go to jail and spend 6 months in soul rot and have his family on welfare. He could elect to take the whip. Somebody got to wondering, how many of those men who elected to be whipped with a strap returned to crime? We call that recidivism. What's the recidivism rate of those that elected to take the whipping? It was amazing. It was practically zero. It was extremely low, which has made psychologists and penologists and legal scholars stop and think that maybe a person who wants to elect to take the whip should be allowed that privilege. At least it seemed to have had some therapeutic value in those Canadian studies. All right, Roman numeral 3, then the blank there was cruel. All right, the Ninth Amendment. This is an interesting one because it provides that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Well, what's that all about? Well, simply this. During the time of the Constitutional Convention, it was stated that it would be very dangerous to include a Bill of Rights. First of all, they said we didn't give that much power to the federal government. Secondly, if you start to list your rights and forget some of them, it's an established principle of law that anything you have listed is concluded to be everything you intended to put in, and anything else was intended to be left out. And Hamilton and some of them said, you just won't be able to think of all of them. And it's very dangerous, and that's Roman numeral 2. It's dangerous to start listing all of your rights. And so the founders put in number 9, which says, now we've listed a lot of our rights, and any that we left out, we include those two among all our rights. We didn't leave anything out, in other words. We didn't give up anything. That's the Ninth Amendment. And that's why they put it in. All right? Roman numeral 3, under their theory of limited government, the founders wanted it understood that they were not forfeiting any of their rights. And it included not only the ones that they had listed, but any that they may not have listed. It was just kind of a protective clause in the Constitution so that nobody could misunderstand. Now we come to the famous 10th Amendment. 10th Amendment says, the powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states, respectively, or to the people. Now let's just kind of clarify that a little bit. What they're saying is, we know there are certain rights the Constitution doesn't allow us, such as coining money and issuing certain types of writs and so forth, and entering into confederations with foreign countries. We know that. That's not allowed, and we acknowledge that. But among all the other rights, if we didn't specifically tell the federal government it could have that authority, it doesn't have it. We kept it. We want that thoroughly understood by everybody. Now, what the founders were doing was putting chains of the Constitution on the federal government. And that's what Jefferson called them, the chains of the Constitution. Bind our leaders down from mischief with the chains of the Constitution. And that's your blank. All right, capital B, unless the government has been specifically authorized to do something, it has no authority. None whatever. And yet we have violations occurring all the time. This is the most widely violated part of the whole Constitution. Now, was President Teddy Roosevelt right or wrong when he said a president could do anything the Constitution doesn't forbid? No, that's upside down. The answer is no. The fact of the matter is, a president can do only what the Constitution says he can do. All right? Roman numeral 2. Constitutional authorities agree that this is the most violated part of the entire Constitution, and that's your blank. The most violated part. Thomas Jefferson said that the restriction of the government, keeping it involved in just certain things, was very important. Here's what he said: I believe the states can best govern over interior concerns, domestic affairs, and the general government over exterior ones, meaning foreign relations and foreign trade. Now I wish therefore to see maintained that wholesome distribution of powers established by the Constitution for the limitation of both. Keep them each in their categories. We'll have dual federalism, and the people will be happy. And the 100 major problems facing America today, we've done research on them, can be attributed to the fact that these chains have been broken, and we have the federal government now coming down and usurping all kinds of authority. Well, there's the Bill of Rights. That's the first 10 amendments. Why did we need any more? You'd think that would be enough, the Constitution plus the Bill of Rights. But it turned out we did need some more, and that's going to be our lesson 13. I think you'll find it very interesting.